Welcome to For Better or For Court, Family Law in New Jersey.
Welcome back to For Better or For Court, Family Law in New Jersey with Ms. Alix Claps. Alix is a partner at Heyman & Fletcher and a certified matrimonial law attorney who helps New Jersey families handle divorce, custody, and complex family matters with clarity and care. I'm Evan Mack, and today we're talking about college contribution. Alix will explain how New Jersey courts decide whether divorced parents must contribute in their child's higher education expenses. Miss Alix, welcome back.
Hi, Evan. How are you?
So, Alix, are divorced parents in New Jersey legally required to pay for their child's college education?
Generally, they are required to contribute, which is a funny thing because married parents are not required to contribute, and parents who were never married are in a gray area in between. But divorced parents generally are required to contribute to their child's higher education up through sort of an undergraduate level.
Wow. So how is a college contribution different from regular child support under Jersey law?
Some cases, the child support remains in place. So if your child's attending one of our many fine community colleges in New Jersey and still living at home, the child support generally remains the same. And all you add on to that is a contribution towards tuition and books. If the child's going to a residential college, they're going to live in a dorm, whether it's in-state or out of state, the child support adjusts further. So there's a reduction in direct child support paid to the parent of all primary residence, and there's an additional tuition and housing contribution from the parents as well.
So what legal standard do courts apply when deciding whether a parent must contribute to college costs?
There is the landmark case in New Jersey is called Newburgh versus Arrigo, and it sets forth a 12-point test that the courts utilize for determining. I'm not going through all 12 points, so don't you worry. But it's a 12-point test that sort of falls into a couple different categories. The categories are sort of like, what was the intention during the marriage about would this child go to college? Where would this child go to college? How much did the parents discuss and agree on the college that has been chosen by or for this child? And what is the need from the child? How much does this college cost? And how much do the parents have, resource wise to pay for it? Those are sort of the four buckets of these 12 factors.
So what about the factors that does your judge evaluate when determining how much each parent should pay?
There used to be in New Jersey what was called the Rutgers rule, which was basically you were required to pay up to the cost of attending Rutgers University, because here we are in New Jersey and Rutgers is our state university. That's changed a little bit. I'll call it now, it's not the Rutgers rule, it's sort of the Rutgers suggestion. Mm-hmm. So the court's going to look at where this child wants to go to college or trade school. I mean, it's not just college, but college is generally the most expensive of the options. So if you're talking about a 4-year school, is it a private school? Is it a public school? What's the child majoring in? How likely is the child to get a job in the field in which they are majoring? Is the child eligible for scholarships or subsidized student loans, separate kind of from private loans, which are a little bit considered different? They're going to look at all of those costs, but it's very, very important that both parents participate in the discussion about which school they select.
So you talked about the type of school, public versus private, in-state versus out-of-state. How does that kind of affect the court's analysis?
They're going to come with vastly different price tags and vastly different resources. I mean, an out-of-state public school versus an in-state public school, they're very different. You might as well consider an out-of-state public school essentially private at that point. But sometimes with private schools, financial aid is a more of an opportunity for a child, whether they are, going to a D1 school on an athletic scholarship or whether it's a needs-based scholarship. There are a lot more opportunities in those schools sometimes than a public school that might prioritize in-state students over out-of-state students. So those are the biggest kind of considerations when we're talking about whether it's an in-state school or an out-of-state school or public school or private school. It's what's the cost difference?
How does a child's academic performance or career plans factor into whether this contribution is ordered?
It's a significant factor. I mean, if the child has not performed well in high school and we don't think the child's going to be successful in college, we have seen cases where the parent of primary residence is really pushing the kid to enroll in school. Sometimes it's community college, sometimes it's a 4-year school, to keep the child support coming, because otherwise the child, if they got a job, would be considered emancipated. And that's just kind of wrong. If the child's going to go to school and not perform well, that's not in their best interest. That's not a good choice for your child. Similarly, if your child is majoring in something that is available in a lot of places, maybe they don't need to go to the $80,000 a year private school to get that degree.
What happens if a parent disagrees about where the child should attend college?
Disagreement is something that a court can resolve. The bigger problem is lack of participation in the process. I have absolutely had cases where a parent who had the financial means to pay was relieved of that obligation because a parent of primary residence and the children who no longer had a relationship with this parent went off and decided where they were going to go to school with no involvement. The other parent was not invited on any of the college visits. There were no conversations. There was nothing. And then they turned around and said, give me money. And the court was like, no, that's not how this works. You get financial contribution when the other parent has participated in the process and been part of the decision making. Now, if there are valid disagreements about what's in the best interest of the child, that's legitimate. That's something that the court's going to resolve. And if both parents are coming in good faith.
Can a parent argue that they simply cannot afford to contribute? And how does that court evaluate the ability to pay?
Absolutely. The court's going to look at the parent's ability to pay. They're going to look at, did this child apply for available financial aid? Is this a cost-effective, college choice? If so, let's say the child gets some needs-based scholarships. That money, that cost is going to come off the top. And then the court's going to look at the parents' financial abilities to contribute and weight that. Doesn't mean they all have to contribute 50-50, and sometimes the child's going to have to contribute. The child may be forced to get a work-study job or to work during the summers to contribute to their own costs. Sometimes the parents are required to take out Parent Plus student loans, something like that, to help support this. And sometimes it's all right, this is what you're able to pay out of pocket. This is what I'm going to order.
So how are scholarships, grants, loans, or child's own, earnings considered calculating, each parent's share?
So financially, you've often got scholarships or grants that don't need to be repaid. You've got sometimes 529 plans. They're pretty common in New Jersey, where parents start contributing to the child's educational costs from birth. So those are going to get sort of used first. They'll be taken off the top of let's say the whole school tuition, room, board, everything is going to cost $50,000 a year. If the grant money of $10,000 and we've got, enough in a 529 account to pay $5,000 a year. So we take that $15,000 off the table. Then we look at, does the child qualify for work study? What's the parent's ability to pay? We divide that up after we take sort of what's available specifically for this education and apply it to that.
If a divorce agreement already addresses college contribution, can that agreement be modified at a later date?
Often, the college contribution provisions of a marital settlement agreement have to sort of acknowledge the idea that we do not know what college will cost when this child goes to college. We do not know what this child's aptitude for college will be, and we don't know what our financial circumstances are going to be at the time. So it is rare for a settlement agreement to be so fixed in terms of college contribution, unless the child is either already in college or on the cusp of going to college. Once in a while, you'll see a case where there's such financial disparity, or there's a trust fund set up for the child's education that everybody knows about that can't be otherwise utilized, where it's very specific. But most settlement agreements are going to be, we're going to take a look at all of these factors at the time. But we acknowledge in this agreement that we all have a obligation to contribute based on our ability to at the time.
So for parents with younger children, is there anything, they can do during the divorce process to avoid future disputes over this, this whole college thing?
Yes. I mean, in your settlement agreement, if you are a person who comes from a family that does not value education past college from an academic standpoint, if four-year college is not in your family history, maybe you've got a family business that you're pretty sure this child is going to become involved in, and they don't need to go, to a $70,000 a year private college to be doing that. You might put into your settlement agreement that there is not an expectation that this child will go to a four-year private institution. You may require that the child do 2 years of community college before there'll be any contribution requirement from the parents. Sometimes you have children with special needs where you can look at it and go, all right, this child has a learning disability. This child has a developmental disability. This child is not going to go into higher education, but we're going to have to make different arrangements for what happens to this child once they finish high school. So that can all be dealt with. You can also, it's not uncommon in settlement agreements for there to be a contribution requirement to a college fund, a 529 or another type of child savings account early on, for whether that's the correct amount each year that has to be saved or a percentage, or just an acknowledgement that, all right, this is what's in the 529 account now. This is what we created during the marriage, and all the growth on that, when we use it, that's going to be used first, and then we're going to worry about what additional contribution we have to make.
Amazing. Miss Alix, thank you so much.
Thanks, Evan.
All right. That's a wrap on today's episode on For Better or For Court. If you have questions about college contribution or want to understand how New Jersey courts approach these decisions, visit HeymanFletcherLaw.com to connect with Miss Alix. Don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.